in the same boat. Hello. What's wrong? It's fine.
But also, can we meet?
Yeah, no, I want to check in with you guys. So today, we're going to be super informal because neither Allison or Bill could be here today for different reasons.
Oh, okay.
So, and if you look at the remainder of the syllabus in any case, this is really about working, this last third of the semester, and about me guiding you in your process of drafting this. And I suspect, if you worked on this over spring break, maybe you start to kind of hit a wall of like, oh my gosh, now that I'm really thinking about this, how am I going to move through it? So that's what I want us to talk about today. And let's just take a look at the syllabus real quick. So, and I brought my calendar actually precisely because I want to make sure I'm going to want to meet more with you guys in these next few weeks on a more regular, just more than what's necessarily indicated on the syllabus, because I want to make sure I'm giving you sufficient guidance. So we're going to talk a little bit about actually individually sort of where you're headed with your opinion, and sort of, are there roadblocks, are there barriers that you need to overcome. Wednesday's class is really just going to be kind of fun, I think, because so the Perry case is being argued tomorrow, and then the Windsor case is being argued on Wednesday. We can talk about both. I think the transcript will be available pretty much immediately for both, but I really want us to focus on what happened in the Perry arguments. And the idea there, it's not necessarily that this is going to influence your opinion that you're writing in any way, but this is more like the current events part of it, right? It's kind of saying, okay, well, what are the justices saying? What are they thinking? What types of questions did they ask? And you can think about, your job as a law clerk in preparing your judge or justice for oral argument, sort of how that might be reflected in looking at the transcript. So I do just want the transcript should be available tomorrow afternoon, and I'd love for you guys to take a look at that prior to our class on Wednesday. I mean, I'm definitely going to probably try to write something pretty, a short piece pretty soon after that, kind of commenting on where the court seems to be going based on their oral argument questions. So that'll be a really, helpful discussion to me as well to have with you guys. Then after that, this again is pretty much we're working on the paper, right? So the following week is set aside for individual conferences, and I think I will actually see if I can go ahead and meet with you all 2 times that week, so kind of check in and then set a goal for the next meeting. And then the next 2 weeks are all guest speakers, but we will have individual conferences, or at least opportunities for those if you guys want to do that during those 2 weeks as well, more in the 3rd week, and then we're going to come together again as a group and discuss issues related to just finalizing the opinion and making sure that some of the more superficial characteristics are kind of put together. But, especially the editing process. I mean, I think we don't necessarily talk a lot in law school about editing. We talk about writing and analysis, but editing is a very important part of this, so we want to get into that. And then assuming everyone's comfortable, the final paper will be due, the opinion will be due on the last day of class, so you can get that out of your hair. And then I just want to reflect some on the semester and get your help in terms of building a model syllabus for the course. So does that all make sense?
So the week of April 1st, we don't have class and we'll just have conferences?
That's correct.
Okay.
Yep. Yeah, so a lot less class time going forward, more individual time and writing time. But I think, again, the conferences are pretty key because it kind of helps keep you on track and make sure that we're doing the one-on-one learning and teaching as opposed to the classroom-based stuff. I think Julie Nichols is coming on April 10th, but I'm still kind of working that out with her. Okay, so let's talk about process stuff first. Okay, sort of, and there's no, I mean, I probably overdo it a little bit as a teacher, but, I feel like a lot of it falls on me to make sure you guys are progressing with your draft as you go along. So if you haven't done as much as you think you should have, don't feel embarrassed or something like that. We're here to talk about the writing process and what the challenges are and whatnot. So tell me a little bit, Kara, we'll just start with you and go from there. Where you're at, where do you perceive yourself as being at with your process? What is coming together, what's not coming together.
So as far as the topic sentence outline, it was really helpful doing the exercise with Kleber and just kind of seeing how well written those sections were and what we're trying to do.
Yeah.
I guess I kind of had a hard time finding the balance in doing that because I felt like I think Bill mentioned that some of those sentences were run-on. So to get it in the one topic sentence, they're either long or you feel yourself doing two sentences. So sometimes I did just do like the first two sentences so that I would know more where I'm going. Yeah. And then I think that this is a really helpful exercise in just outlining where I'll be going, but then I was like trying to find the balance between looking into it, like how much detail to go into, right? Like with the topic sentence outline, it's like, I don't know if this is going to be a 5-paragraph section or a 1-paragraph thing, and so do I need to like flesh out the topic sentences more? And
it's obviously going to be a lot of back and forth with that as you go along, right? And the idea behind the topic sentence outline is that you are thinking about your argument as being organized by paragraph. And so, of course, if you don't have a lot of experience sort of doing topic sentence outlines in particular, it's going to be hard to judge. What is this, what is a self-contained paragraph versus 1 or 2 or 3? But that's fine for it to expand and contract as you go along. It's more the exercise of formulating your thoughts and articulating yourself that way. That's kind of the purpose behind it.
So I think I have a good outline of where I want to go, and then it'll just be challenging to fill in the meat. And I mean, I just not writing this as like, this is my opinion, this is like what I think I want the court to decide, but like this is why it should be grounded in law and precedent.
Yes, right, okay, so, and that comes all the way full circle back to the beginning of the class, right, and thinking about the function of judicial opinions, how that's expressed in the voice, in the content, in rhetoric and everything else, right? So you want to, and this is a key thing that you're going to be doing with this exercise, with this paper, and then working on in your clerkships, is internalizing that judicial voice and making sure that that's, you can write that voice, you can adopt that voice. And this decision could come out a lot of different ways, but regardless of the outcome, it has to be grounded in the law, right? And that's, again, sort of a difference between thinking about this as a political issue versus as a legal issue, okay? Any other thoughts?
I guess a small thing that I found myself struggling with was, like, when articulating the law, how much to be quoting and how much to be paraphrasing, and then especially with the equal protection analysis, there's a lot of
boilerplate kind of?
Yeah, right, that you're not going to paraphrase, like, compelling state interest, narrowly tailored. You're not going to, like, change the words. So do I use quotation marks, or are those boilerplate enough that if you just cite the case, it's okay? So I think, I struggled with that when I was interning, too, for a judge, because you're, like, citing either, other courts' opinions or your courts, and so you don't want to plagiarize, but obviously you're citing it. So how much do you need to quote, or how much do you need to worry about changing the, like, order of the words and stuff?
Yeah, and how much brain damage do you want to go through in that process, right? So let's kind of separate out the treatment of the language and the concepts from the issue of citation. Citation, if it's a legal proposition, it should have a citation. So, and that's, a big... that sort of reliance on citations and actually seeing citations as something that strengthen the presentation's argument is kind of a big shift for a lot of people, going through law school and whatever. But certainly as an advocate, but also as the court. If the court doesn't provide citations for all these propositions, then it's not being as transparent as possible, right? And I think anytime a court makes an assertion, fact or law, without a citation, it's a big red flag in terms of how I read cases. But so proposition of law, include a citation, don't do string cites, right? That's really disfavored at this point. Courts might vary, but generally the modern trend is to avoid string citations. And then in terms of quoting versus paraphrasing versus using terms of art. Okay, so compelling state interest. This, if you're going to say under strict scrutiny, a classification must be narrowly tailored to serve a compelling state interest. You could quote that, or you could state it as sort of recognized terms of art without the quotation language and simply have a citation to it. Because those are in such common parlance that you don't need to use quotation marks every time. Stylistically, what's the trade-off between using quotation marks versus not? Like, what do you think when you read an opinion that, let's say, has excessive reliance on quotations?
It
You're
looks,
not providing much individual thought into it.
Okay.
it looks lazy, like they're just
Kind of piecing it
copying
together.
and pasting from a bunch of other stuff.
Same thing.
Yeah.
Yeah, okay. So,
Well, and I think when you read, because usually it's kind of like when they're doing the old law part,
yeah,
it's a lot more quotations, and then when you're getting into whatever their
more recent.
rule is, or whatever their rule is, then it's not. So it's kind of easy to skip over.
Oh, okay. That's a really interesting insight. So quotation has this kind of distancing effect, right? And the court is this sort of continuous entity from the day of, Plessy versus Ferguson until now. It's the same, it's the same court sort of in this this fiction that we use. But the court may at times want to distance itself more from certain reasoning or language than it does later. And so quotation marks can be strategic in that sense too. So I think that when is a time where you, not must, but you really should use quotation as opposed to paraphrase? So right, if you do as a default, it's just kind of lazy, right? But when
It's
should
not
you?
a term of art, but it's something that, like something poignant or important from another decision or like one of the parties' briefs that there's no reason to paraphrase it because that, your point is to say what they said.
Okay, good. So actually, and that's a really good point with the parties' briefs. Because especially if you're going to condemn or criticize a party for making a particular argument, it's a lot more sort of honest and persuasive to quote the exact language that they use. So if you're going to critique a lower court decision or one of the parties' arguments in the briefs, I think that's a really good time to actually use quotation marks because it gives you credibility that you're not just kind of erecting a straw man, as they say. But also where is the language saying something sort of unique, right, that you want to recognize is attributed to this prior source or whatever, and that, the language is particularly powerful, and so you want to preserve it just as it is. I think that's a really good time and a good reason to use quotation marks. But so, yeah.
The question with that is that almost like it's almost like an intermediary before, like it's like taking a prior court holding, and then that becomes a term of art. But it's kind of like that first use.
Oh, the sort of the evolution from novel phrase to term of art.
Yeah, is that kind of where you would see it being used, or?
Yeah, I think that actually that's a great way of thinking about it. So that when something is a novel term of art, you're going to want to attribute it to the source and use the quotation marks. But once it becomes part of common parlance, it's a little clunky and awkward to do that.
Right.
So it takes a little bit of sensitivity to figure out where are you on that spectrum.
Okay.
Okay. And in terms of paraphrasing, so this is the thing, right? This is why it's so different than our intellectual background prior to law school, right? If you're kind of struggling to restate something, that probably means that it was stated really efficiently in the first place, and so you might as well quote it, right? Even though we don't want to overly rely on quotations. You don't want to go through an artificial exercise of trying to restate it or avoiding quoting more than X words. For me, when I draft, I start with a lot of quotations, and then I paraphrase kind of where it makes sense, or especially the quoted material, and then there's sort of the meta paraphrase, right? So you could quote everything that the court said in its reasoning, or you could say, the court next considered whether this was a suspect classification, looking to the factors of, immutability, history of discrimination, etc. Okay, so it should kind of become an intuitive thing of when it really makes sense to quote something. And that really, what it means is that the language is important, either because of the particular way it was stated or because you're actually holding it up as an object of something you're going to criticize somehow. Okay?
Okay.
Okay. Other thoughts or questions about your process? And we'll talk about content later, but we want to talk about process first. Well, let me say one quick thing too. The idea of a topic sentence outline is, and I'm working on this with my own article right now, is kind of trying to go back in and rework the topic sentences. But it really focuses you on making an assertion in each paragraph, right? Rather than just kind of having something be descriptive or whatever. So it really puts you in that, analytical frame of mind and makes you take a stand on whatever particular issue you're talking about.
Yeah, and I felt like that was a good exercise, and I think I did that, and so now my next concern is like, okay, how am I going to back this up? Like,
Okay.
I mean, or I know that I can back it up, but it will be an exercise to,
Yeah, what does that look like? And, okay. Right, because if you get your topic sentences worked out pretty well, then the next thing is actually drafting those paragraphs, and then that's going to inform revising the topic sentences and the structure and things like that. But so let's talk about that in the context of maybe a particular assertion that you're making. Okay, when we go back and talk about content.
Okay.
Well.
Okay. I don't know if mine's quite as thorough yet, but I pretty much started with just like almost the rules of law.
Okay.
So almost having those as my topic sentence, so that way it provides kind of the structure and framework for it, and then that'll guide my analysis and how to kind of get to a disposition.
Okay.
And then I kind of went through and I took a lot of Cleburne because that definitely was the best written out of each case. And then I went through and outlined each, like the 4 cases they provided me to help out and kind of develop what those rules of law are.
Good.
And what I'm working towards is trying to figure out what rational basis really, or what rationally related really is for law. And so what I've kind of
knows.
So what I'm kind of trying to do is like basically synthesize that into some kind of rule or analysis or some kind of standard.
And tell me again what the body of cases is that we designated.
Yeah, it's Cleburne, Romer, Moreno, and Plyer.
So and those are all the exceptions, right? To
When rational basis like actually defeats the law.
yeah. And the thing is, I mean, right, it's sort of, there's a correlation between the construction of the rational basis review standard and the outcome for the plaintiff, right? So, and I don't know if we've talked about this a lot, but in cases where the court is really emphasizing the deferential nature of rational basis review, plaintiff's going to lose in those instances, right? Mm-hmm. And Heller versus Doe is a really good example of this. These cases, the court really is applying a different standard that, rational basis with bite or heightened rational basis review or whatever you want to call it. So even by selecting these cases, you're kind of, making a strategic decision. But then I like your idea of, and like a comparative case chart might be a really good tool here. Mm-hmm. Like, what is the exact language that the court used in assessing the rational relationship in these 4 cases? And I've been thinking about this in terms of what is the court really putting into this tailoring requirement? Like, what is that really about? Why does it matter if there's a fit, right, between means and ends? And there's kind of 2 veins that I'm seeing. One is sort of like, well, how accurate is that proxy, right? And in Cleburne, they're like, this is just really not an accurate proxy, and that's not okay, right? Whereas with Plyler, it might be a sufficiently accurate proxy, but there's just something offensive about punishing children for the conduct of their parents, right? So it's sort of, I think you'll find some interesting themes in there in terms of what, does the court care about when it talks about whether something is rationally related.
Okay. One thing with mine, I've kind of avoided or almost left out. Like I moved probably too quickly almost into rational basis based on Romer and based on their assertion that they dealt with a sexual orientation and that they just applied to rational basis review or determined it as such. And so it's like I don't really look too much at the classification of sexual orientation. I kind of just leave it as decided in Romer, and then move to like the rational basis or rationally related review. Like what are the standards for that?
No, I think that's right. I think that's right. I mean, your focus is on, I think, a very important, both judicial project and academic project. What is rational basis review? What exactly does it require?
Okay.
And to describe that with precision.
Yeah, and then I still need to go back and look at what some of the justifications for the law that have been provided, to whether or not I need to go into legitimate state interest kind of analysis as well, or if rational basis would.
Well, you've got two choices. I mean, you can concede that interest as being legitimate without even analyzing them, and then question the rational basis part. But tell me a little bit more about your process. So you talked about you're focusing on rules of law and trying to synthesize a comprehensive rule of law. And what kind of principles do you use in terms of, what does it mean to synthesize a rule of law? What are the requirements?
Initially, I guess I was just kind of like looking for like almost like holdings or some kind of analysis for each case, and then trying to see.
Right, X is not rationally related to Y because.
Yeah, because of these reasons, and so trying to like remove those out of the case, and then try and almost have like that because statement for each case, and then see if there's an overlap between them. Okay. And then how those are related. Okay. And then, or if there's something new that's outside the bounds of a previous case. Okay. So like, are they establishing another factor or component, or? Okay. So yeah, the one scenario is like, oh, it's totally congruent, right? A, B, C, and D are all here in the same circle. Yeah. Right, which I don't think is the case with those four cases, right? The other situation is, okay, can I find this little area of overlap? Right. And then the other situation is, maybe there's overlap and other there's not. Is there a broader rule that encompasses all of them? So these are different ways of thinking about synthesizing a rule of law. Right. Okay, so the overlap may end up telling you everything you need to know, but they may be the cases, the reasoning there might be disparate enough that you have to pull back and look for larger principles. Yeah, I almost kind of look at that as almost like, that would be like an element where it's like, you need every single factor, like you need every one, and then moving over here, it's like the factor, so it's like an OR test. I mean, if any one of those apply, it could be rational. Okay. So well, that's interesting too, because you could say, here are four ways that a law is not rationally, that a classification is not rationally related to the purported state interest. Right. And you could either try to find a unifying principle or not. Yeah. You could just say, these are just four different ways. So, but that would be very useful. That would be a very useful project. Yeah. Okay. So that's a good concept of synthesis. Okay. So for you, if we think about the meta IRACs here, for you, the issue is really, what is rational basis review? Right. And that development of the rule is going to be kind of the bulk of your analysis, right? What is the rule for rational basis review? It'll be like a synthesis establishing what is rational basis, and then essentially like an application of the law, given like what do we have here? Like responsible procreation, if that's rationally related, like proceeding with caution, or like a democratic self-governance. I think that one's a little outside the loop, but so it's kind of be like applying those rationales to the application, right? Exactly. So once you synthesize your rule, then you're going to bring that into your application, and again, just reading off those interests. I mean, those are all legitimate. Yeah. That's not the issue. Yeah. The issue is whether there's a rational relationship, and again, under traditional rational basis review, sure. I mean, traditional rational basis review does not constrain arbitrariness, really. But a more vigorous, meaningful form of rational basis review of the type that you're developing might find some of those means-ends relationships insufficient. Yeah, and then I guess that does bring up a question for me as far as, when you look at the type of interest, like if it is a fundamental interest or like that kind of heightens it a little bit because rational basis is pretty much just like a deference, like, okay, we don't even really look at the record. Like it,
This is the
kind of
thing
refer
with,
to the legislation in it.
yeah, and
So this is
I don't know
almost
that
like
you need to tackle this, but
Okay.
what's inconsistent as between deferential rational basis review and rational basis review with bite, one of the
Yeah.
big inconsistencies is where the court actually places the burden of proof.
Yeah, like what's the triggering effect to establish, which one they're going to apply to?
Politics, I mean, is what some people would say, I mean, I think the court has really dropped the ball in terms of explaining rational basis review in any kind of consistent way. But
That's what I noticed in a lot of the dissents is just like, we're like, why are we,
Yeah.
we're calling this rational basis, we're applying
Right.
a different standard.
Right.
Uh,
Right,
so-
and it's sort of, right, I mean, most people would say that, rational basis with bite is basically, until they articulate a principle for it, it's basically a results-driven kind of, choice,
Yeah,
right? We don't like this law, we don't have a basis for saying heightened scrutiny should apply,
yeah,
but we're going to apply rational basis in a way that will defeat the law.
yeah,
And that, that is gonna lead to pretty powerful dissents generally.
okay,
But the issue of the burden of proof, so under deferential rational basis review, not only does the state not have to provide any evidence of an actual state interest, but the
Right.
court can speculate as
Okay.
to potential state interest. So you're gonna kind of have to decide where you come down on that issue
okay,
of the burden of proof. Because like, what I think is interesting is you see in, let's see, like Plyler and Claiborne, the court's kind of saying, well, the state hasn't, we looked in the record, the state hasn't offered evidence of X, Y, or Z. Well, that's really not rational basis review. And so, Will, one of the important choices you're facing is whether to own up to what you're doing
yeah.
or not.
Yeah,
Because what the
I
court
think-
typically does is say, oh, this is clearly what rational basis review is. And that's a fundamentally different approach than saying, we've been inconsistent, and here is why we're going to formulate rational basis review this way.
Okay,
And that honestly would be, this latter approach would be more interesting.
yeah, since I'm not establishing a Supreme Court decision, it would be nice to just kind of establish what is, just to sum up what that consistency
Yeah.
rational basis review would be,
Yeah.
and what the burden, where the burden lies.
Yeah,
what
and
kind of-
why,
Yeah, but, I'm inclined to kind of move it, like, kind of almost leave it as the court can speculate, and the state has no burden, and so it's like, it's on
Okay.
the plaintiff to establish a level of proof, but looking at this factual record and everything that's there, I think it would be enough to establish, that this law is not rationally related.
Okay.
The court, it would leave the court with no.
Are you going to limit yourself to the purported interests that are actually offered by the proponents, or are you going to, so that's
Yes.
one thing to think about.
Okay,
But the advantage you have there is that you have the California Supreme Court saying, this is the limit of what Prop 8 actually does. So there's, you could say, well, maybe they passed Prop 8 to, who knows, I don't even know, for some other reason, but there is sort of a limit that's placed on the speculation based on what the
Yeah.
California Supreme Court found. That would be clever. That would be a clever
okay,
resolution of that issue. There's only so much we as the court can speculate about in terms of what this law is supposed to do, because
okay,
these
so
were the
some kind of
findings.
limit to speculation.
And so that what you're doing there is you're really using lower court findings and sort of
Yeah,
standards of review to do an end run around the substantive.
yeah, it seems better, leaving it open to speculation, it's like, you're gonna lead to arbitrary decisions
I tend to agree.
all over the place.
I tend to agree. And I think the idea of the judiciary imagining justifications for a law kind of is a problem from the separation of powers perspective, but that is one of the aspects of traditional rational basis review. So if you can find a way to limit that, that would be an interesting thing.
Okay.
Okay.
Legislative history, it's gotta be some way to limit it, I think, as well, too.
But then you are shifting the burden.
Okay.
So, I think
If that
it's,
legislative history gets shifted to the state, are they gonna have to?
if you are saying there has to be support for this in the record, then you're
Uh-huh.
putting the burden on the state,
Okay,
right? Which I think, I mean, as a plaintiff, how could you prove the absence of something that the judges are free to imagine? I mean, just as an evidentiary mechanism, it's, I think, really problematic.
Yeah.
So you could also, I mean, so that this is a tone issue, right? You could say, you know, we've said that we're free to speculate, and that was just a terrible idea. And today we're changing direction.
Okay.
Right? Or you can do the sort of, well, when you really look at our cases,
Okay.
what they in fact do is, you know, they look for some basis in legislative history or something like that, which is really not true, but this is the kind of thing the court would say.
Okay.
Okay? All right. So yeah, tell us about, we got into more content stuff with Will, which is totally fine, but let's try to talk about process some.
Well, I think my problem with my process is more about my content.
Okay.
That I really don't know. Because we had talked about the two approaches that I was thinking about taking, and I thought about doing the rational basis review about creating a permanent underclass. But I really don't still know how to get there, I guess.
All right, so let's.
So then
let's
my
actually,
default was to do the suspect classification analysis, because there's kind of a lot more there.
Yeah. Taking the suspect classification analysis as it is, and then just looking at whether the facts meet that.
And I mean, with the ultimate conclusion that it would require some type of higher scrutiny.
Well, and the thing is too, if you're writing a pretty decent length opinion just on suspect classification analysis, you can actually, again, you can bracket then the application of heightened scrutiny. You don't have to feel like you then have to write an entire other section applying heightened scrutiny, because in your case, if you go that route, suspect classification analysis is really the most controversial part of it. So I kind of would focus on writing that. To sort of situate this permanent underclass idea,
well, I know that it would be
in
a
IRAC.
rational basis that, but then you know, kind of what you guys were talking about, that it would require. I mean, my thoughts were of kind of redefining or further explaining what rational basis review is.
So let kind of pull you back a little bit.
Yeah.
So the question is, and this is sort of this very enigmatic question in the court's jurisprudence, when does a law fail rational basis review? Okay, so it fails if there's not a so-called rational relationship, right? It also fails if we could think about a number of ways. There's animus, if the law is motivated by animus, right? If the law performs an impermissible function, such as creating a group as a permanent underclass, okay, you could think of that as a sort of a species of animus. And then the question, the lingering question is that really it kind of makes no sense, you know. Well, does it have to be that there's no rational relationship? And, you know, what if you had a rational relationship, but you clearly know that the law is motivated by animus? Should that law be struck on that basis? And I think the answer is clearly yes, but the court sort of muddied the waters there. So what you could do, and there's a pretty clear set of case law I think that you would want to draw on, but so you'd have two questions. Okay, so the first question is, well, when does a law fail rational basis review, right? It fails rational basis review, obviously, if there's no legitimate state interest, if there's no rational relationship. It also fails if it's apparent that the law is motivated by animus, okay? And one species of animus is this permanent underclass idea. Second question, is the presence of animus alone sufficient to defeat the law? And I think it has to be, because again, why would you say a law has no rational basis and then go on to find animus? It would be gratuitous, right? And then, you know, when you look at what the court is really doing in these animus cases, you know, another way of reading rational basis with bite is that it's really concerned about animus. The court senses that there's animus and it ups the standard somewhat, which is Justice O'Connor kind of said in her concurrence in Lawrence. So those are really the two questions, you know, or really it's the questions would be, you know, what is an impermissible function or what is unconstitutional animus, and is that a silver bullet that then defeats the law regardless of a superficially rational basis. And if you were to look at that, I would just limit yourself to the, the so-called animus cases.
Okay, meaning, the ones you had given me to look at were Heller v. Doe, Romer, Claiborne, Moreno, Plyler.
So the recognized animus cases are Romer, Claiborne, another case called Palmore versus Sadati, and then Moreno. And notice the overlap with the cases that Will's looking at. These are also the heightened rational basis review cases. Unrecognized animus cases include Plyler.
Romer.
Romer's a recognized animus case.
Okay.
Yeah. And Heller v. Doe is in there as a point of contrast. Okay. That goes more to. That really sketches out this very problematic version of deferential rational basis review. So that's sort of more background information, but it's not a case you would actually use to support your point. But if you, and again, I want all of you to kind of limit yourself in terms of the set of cases that you work with, but if you limit yourself to those 5 cases, you're kind of doing the same thing that Will's doing, which is a rule synthesis. And you're going to look at each of those cases, and apart from whether there's a rational basis, what is the basis on which the court concludes that there's sort of an impermissible function? Okay. So Romer is the worst because Romer says there's no rational basis, therefore it's animus, right? Claiborne says, there are 2 reasons. Sort of 1, there's no rational basis, and it would apply to heightened rational basis. But 2, you have on the legislative history and the record these folks from the neighborhood coming in saying, we don't want retarded people living here. Okay, so you had this affirmative evidence of prejudice and stereotype. Okay? Palmore, you also had this affirmative evidence of prejudice and stereotype. And Moreno too. And Moreno, you had members of Congress saying, we don't like hippies, we don't want them to get food stamps. Okay? Plyler is kind of the pure, functional kind of take on animus, where it's like, if you deny education to the children of undocumented immigrants, you're creating them as a permanent underclass. So the other thing you could do is try to just use Plyler as a single precedent, giving you a framework for looking at this issue. Okay? Marriage is, we all recognize that marriage is this sort of platform in society. And if you designate a group to, exclude them from that, you're creating them as a permanent underclass.
But then my problem with that, because I thought about doing that, but then, that doesn't really get us anywhere else as far as further determining what, making rational basis clear.
It does. It does. Okay, so because right now, on the level of what does it mean, we know legitimate state interest is pretty much anything, right? And the court can, the state can always easily articulate the legitimate state interest. But the open question is, well, what does rationally related mean, right? But what you would be proposing is a separate ground for finding the law fails rational basis review. That's not based on tailoring. It is based on the function of the law, which is creating a permanent underclass. So that would be your rule articulation. And then if Proposition 8 creates a group as a permanent underclass, then it fails rational basis review as your application.
Yeah, that's definitely something like my synthesis doesn't expand into, is that...
They're 2 separate issues.
Yeah, creation of separate underclass, I don't think it gets that. It doesn't go there.
I think it's really, I think they're really different issues. And they both really need exploration. But this idea that what is the larger purpose of the Equal Protection Clause? And again, we've taken it beyond slavery, right? We've taken it beyond its specific historical context. Is it essentially this anti-caste mandate? The public laws cannot be used to create permanent classes in society. And again, there's a sort of status conduct distinction implicit in there. Because if you're imposing legal burdens based on conduct, that's a totally different thing. If you're imposing it based on status, that's permanent, that is, unrelated to individual merit, etc. But it's pretty heady stuff, so.
Yeah, that's pretty cool. I mean, that gets into like kind of the whole American dream and like the whole
Absolutely.
reason for, the whole revolution against Britain, like the established of these birthrights and everything else. So.
I think there's a lot of that sort of political culture of democracy is really infused in equal protection jurisprudence, but it's not always sort of front and center.
Yeah, but I mean, I think it's good too. I mean, like if you establish this case similar to Plyer, it kind of gives it more weight and kind of reconfirms that like that's kind of where they're headed. And it's like even though you're not defining rational, like what's rationally related, you leave that unknown, but at the same time you kind of create more of like really the purpose behind equal protection, really what it's there for. So.
Well, yeah, no, I think that's right, and I think part of what you're doing there too is kicking Romer to the curb, which obviously you guys know is kind of my agenda, but just saying, Romer doesn't really give us a lot of guidance about. There's some threshold beneath which a law cannot fall, right? In terms of equal protection being sufficient for equal protection purposes, and what is that threshold? Right? Is it, there was hostility toward this group, whatever, or is it this law has a function of the type that the Equal Protection Clause does not permit? And what is that function? And I just would say too, like if you're struggling, that's good.
Yeah.
For all of you, these are not easy issues. I mean, many of the greatest minds in the country are working on precisely these issues. So part of your challenge is to be at some point like, I'm writing doctrine now. Like I could go on forever thinking about all these theoretical issues, but I'm going to look at the cases and I'm going to write some doctrine. Which is great. That's a really fun thing to be able to do.
Okay.
Does that feel, as between the two approaches, which one do you feel like is more doable?
Doable, I think the suspect class, I think that there's lots of writing on that part, and but I think that the permanent underclass is something that's really interesting to me.
And that's what I would do.
I definitely struggle with it more, but I think that it would be interesting to do.
There's less writing on it though, it gives you more flexibility.
Yeah. Yeah, no, that's, again, like I don't, this issue is very under theorized, and hopefully the court, and then we'll get a sense on, tomorrow, if that's potentially something the court is interested in figuring out. But again, for all of you, your job is not to develop a theory. Your job is to develop a rule of law. And that's actually kind of some of the comfort in this, because if you're writing a paper, there'd be no end in sight. You're writing an opinion, and it has to be based on precedent. So there's a limit to how much you can kind of speculate, and the brain damage involved in this, right? Ultimately, you need to look to precedent and find that, a way of supporting your claim that it supports a particular rule of law. And that's just different. It's different than saying, what is strict scrutiny? Strict scrutiny, compelling state interest, narrowly tailored. That's not, it's easy to go into a case and find that. What you guys are approaching is really working with massaging cases to kind of extract this meaning that is, you have to defend as being the proper meaning there. Okay.
Something that I'm facing that I kind of bracketed in my outline is, like we had talked in our last conference, that I could just say, since I'm doing just a reminder, I'm doing the heightened scrutiny for sexual orientation and strict scrutiny. So I could say that because I think this might fail rational basis, I'm going to go to strict scrutiny. But and then it kind of goes into like Will's thing. Like I think it would fail real rational basis where like the challengers always lose. But if it were rational basis with a bite, we don't know what that is. Romer sucks. So I didn't know it, but I also don't really want to go there because I'm going to strict scrutiny, so I don't want to spend.
You don't have, you don't even, so this is another part of the writing process issue, is teeing up the issues, right? Use the parties' arguments and the decisions below to tee up the issues. So you can simply go, and I apologize, I don't remember exact context of our conversation around that, but the plaintiffs argue the sexual orientation is a suspect classification to which heightened scrutiny should apply, and launch right into it.
So I don't even need to say how I think it would come out on a rational basis?
No, because that's really, would be dicta,
Right. So it's like,
So,
I'm going for strict scrutiny, so just go there, don't talk about
Yeah,
if
yeah,
this.
yeah.
Okay.
I mean, there are times when you need to acknowledge the fork in the road, but there are other times where you can just totally ignore it. It's
Okay.
partly driven by the substance of the argument, but it's partly just driven by rhetoric too. Or you can kind of gloss over it with rhetoric.
And same with due process. I mean, like in some of the cases and even the briefs, they're like kind of, well, I know if it's a fundamental right under due process, it's strict scrutiny, but then if it's equal protection, but sometimes I feel like they kind of conflate the due process and the equal protection, so I like find myself going towards fundamental right.
Yeah, so
But I
just
wanna
think
say-
about it, think about, and we did that diagram early in the semester, think about it as that is definitely being a fork in the road.
Okay.
Either you're going to go down the classification prong or the fundamental right prong.
Okay.
If you're going down the classification prong, you don't need to talk about the fundamental right prong. And it's also, there only needs to be one basis for the decision. The question is, which basis will that be? And you guys can see there's so many different options. But once you choose a path, stick through that. Stick with that path. Okay?
So is my perception as far as like a court wanting to move as quickly as possible to like this positive issue and then like not addressing anything that's not a true case of controversy? I mean, is that really?
That's what they should be doing.
Okay.
That's what they should be doing.
'Cause that-
And so
that
Claiborne.
provides some comfort. to
Yeah,
people,
no,
like,
no,
writing
that's
this,
right,
'cause
that's
it's like-
right.
Because there's so much we've talked about and discussed, but
Yes,
it's
but you're choosing one path.
like, yeah, now it's like, okay, I just want to go right here,
Mhm.
and like, there's a reason, like that omission for discussing other issues, there's a reason for that, like,
It is case and controversy, it is, judicial restraint,
okay.
deciding things on the narrowest grounds, constitutional avoidance, all of that. And again, that's what, I think is one of the real beauties of legal writing. It's functional. And we're not here just to explore these ideas. We're here to resolve a case on proper grounds. So choose your path and follow that path through the conclusion. There's no need to address other issues. And it would be actually, going beyond the scope of what the court should do. Of course, they do that all the time, but, okay.
I think when I started law school, it's like I almost felt like they should do that more. Because it's like, if you got this case, you might as well just develop, this body of law. At the same
It
time,
makes
like-
sense from one perspective,
Yeah,
but,
after going through like constitutional law and admin,
Yeah.
it's like, you can see why that's not what they want to do at all.
yeah, you want the parties to be fully engaged
Yeah.
in debating the precise issue that you're going to decide on. So you have that discursive process.
It's like the opposite of what we're trained to do in law school, though, because on exams they're like, hit every issue,
true.
and if you're wrong, like hit the 50 other issues that could come out of it, whereas like as clerks, we're like only supposed to be going to the dispositive one, not talking about everything under the sun, and especially with this, like we could write like 50-page papers or...
Yeah, it's right, 250 pages.
Yeah.
I mean, exactly, and I think, and that's part of the reason I think it's good to have a class like this, is to really think about, the different types of writing you do in law school, and then what sort of the mission is here. The issue spotting is good because you want to be able to say, well, we could decide this on suspect classification, we could decide on fundamental right, but when you get to the work of solving the problem, you have to kind of, commit yourself to a particular approach. So try to give a 1-minute summary of your argument, or your analysis.
Okay.
And let's go ahead and do an IRAC form. All right?
Okay, so my issue is what level of scrutiny sexual orientation should be subject to.
Okay.
And my rule is that the Supreme Court has looked at various factors throughout its jurisprudence, including history of discrimination, ability to contribute to society, immutability, and political powerlessness.
Okay, I'm going to stop you there. So we're doing a nested IRAC, obviously.
Yeah.
Right? So the issue is what level of scrutiny. The rule is, are you going with quasi-suspect or suspect?
Suspect.
Okay. Rule, if suspect classification, then strict scrutiny. Sub-issue. is this a suspect class?
Right.
Rule, here are the factors we've looked at, then what do you do with those factors?
I am saying that immutability and political powerlessness are not relevant to my analysis here, or should not be, or are not relevant to the
Did I
court's
give you that
analysis.
Eskridge article?
Yes.
Okay,
Yes.
so that, I mean, he really sets out the case for that.
Right.
Good.
Yeah. So I don't know, I'm probably skipping a million.
No, so you're saying, okay, well, here's the rule as it has been, and I'm gonna modify it. And I'm gonna say, you know, political powerlessness and mutability are not that important. What's really important about suspect classification analysis is,
History of discrimination.
great, okay. And so that's gonna be for you the controversial piece, is saying, you know, let's really look at what we're doing when we do suspect classification analysis. Then you're gonna apply it, and you have ample evidence of a history of discrimination. Is there any, I mean, I think the real work again is saying, why? Why is it history of discrimination that's the most important?
And then also like ability to contribute to society, but I don't know how much I would want to go. I feel like the the strict scrutiny is kind of all over the place. Like some opinions, they talk about these factors, some they talk about these.
Yeah.
High-tech gays,
Yeah.
leave them out, but they, like one opinion will say 4 out of 5, some will say 5 out of 5.
Yeah,
So I'm trying to do the synthesis there.
Yeah. Well, and again, I mean, there's a lot of literature you could look at, but I would kind of let Eskridge be your guide there. And cite to him. I mean, he's been cited by the Supreme Court before.
Okay.
So there's the claim, the empirical claim,
Mm-hmm.
that history of discrimination is the most important factor, and then there's the theory behind it.
Okay.
Okay? And what's the theory behind it? Just, I mean, guess, you know. Why? Why should the court protect groups that have historically been discriminated against?
Because without their protection, they'll continue to be discriminated against.
Okay, so there's basically two theories. So one is, and you're looking at, I think Loving has this statement in it, but basically, if you've been discriminated against, chances are that laws relying on that type of classification are really just about the desire to discriminate and not a legitimate public purpose. The other theory is that if you've been historically discriminated against, you're politically marginalized and you can't defend yourself in a majoritarian democratic society. And you could talk about both of those. Okay. And I would say, you know, you're going to find that in Eskridge's work, and if you're having trouble backing up some of that theoretical stuff, then.
Okay.
Okay.
And then also, I mean, so I think another thing that this just raised was I also have Janet Haley's immutability.
Mm-hmm.
I feel like that's like really, not as helpful as Eskridge.
Mm-hmm. I think that's right.
And I mean, I like the idea of discussing that the court should not decide whether sexual orientation is a mutable trait.
Mm-hmm.
But I guess I don't know how much to go.
Mm-hmm.
How much of my opinion should be immutability doesn't matter, political powerlessness doesn't matter,
Right.
but history of how much weight to each of those three things.
I think you can make a pretty sort of strong argument that political powerlessness doesn't matter. Immutability doesn't matter. Haley's probably not great support for that as much, and Eskridge does give some support for that, but it's sort of, you know, I mean, how many groups are not immutable, right, that have been recognized? I mean, that's part of it, you know, if you just look at the court's jurisprudence. So then I would say Suzanne Goldberg's article, Equality Without Tears, T-I-E-R-S, not T-E-A-R-S. She kind of says, okay, the court's all over the map on immutability. That shouldn't really be considered. So you can take a look at that. But that's, I would say each of those could be 3 paragraphs. Political powerlessness doesn't matter, immutability doesn't matter. History of discrimination matters, empirical support from the case law, why? Theoretical support.
But that one's more than 3 paragraphs.
Yes.
Okay.
Yeah, I think so.
Okay.
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 I mean, the seminal article on that is Beyond Caroline Products by Bruce Ackerman. And it's sort of like, oh, Caroline Products footnote 4 is concerned about, you know, groups that are politically marginalized. But, you know, you can sort of mine the Eskridge piece too for some of those ideas.
That's Bruce Ackerman, Beyond Caroline Products.
Yeah. Okay. So you gave us some insight to it, but try to do like an IRAC of your thesis.
I was just thinking about, like, my large IRAC is just basically does a law defining marriage between one man, one woman, survive equal protection.
Mm-hmm.
But then, like, working down to kind of where I need to put some effort is in this synthesis. And like, I think that IRAC down there is going to, or the issue is more, when does a law fail rational? When is a law not rationally related to a legitimate state interest? And then
here's the examples.
And then here's my rule that I wrote out, and I'm kind of thinking through it now.
Okay.
So a law lacks rational relation to a legitimate state interest when it represents mere negativity or fear towards a particular class.
That's the animus piece.
Yeah, that would be more animus there.
Mm-hmm.
It fails, and then that's when you're asking if that's sufficient, and it turns out I constructed it as an or, not an and statement. So. Next is if it fails to distinguish reasonable factual differences between an unpermitted and permitted class, and that's kind of looking at
well, Claiborne is probably the best.
Yeah, Claiborne's the best as far as the housing.
Yeah.
Between the zoning codes.
Yeah.
And then a law has an excessive burden that outweighs the intended legislative goal.
That's Rome rule.
Yeah, and also I think.
And that's actually Moreno too. Good call.
Well,
yeah, good call.
Targeting hippies and affecting people well outside that classification.
Right, and that's probably the most tenuous. When you're talking about, the kind of majoritarian concern. It's right. If the court come in and be like, oh, you're hurting too many people, it's a little tenuous, but I think it's an interesting idea, and I would definitely develop it.
Yeah, they're definitely. That's the one that's like. That would probably defeat this law, is that there's some kind of excessive burden beyond the legislative goal. It kind of almost marries, though, the two rational, like the rational relation and the legitimate state interest. Because it seems like it would then tie, like, the state to define what that goal is. And that the analysis then would depend on what that goal is, and then that excessive burden.
Yeah,
So
which is really Romer's innovation, and it's not necessarily. Totally invalid, it's just sort of unprecedented, but I like that. So it's kind of like, when does a law fail rational basis review? And then you're going to give the examples.
Yeah, and it would
then you're going to
almost
analogize.
limit like the speculation, I think, a little bit, because that way, instead of just, it could be any legitimate state interest, it's the stated, like the intended one that they've provided.
Good.
So that's kind of.
Well, I think one key thing there too, the relationship between the state interest versus the actual function or effect.
Okay,
those are two different things, but think about how they relate to each other.
Okay, yeah, function effect, I think that's where Plyler kind of moves into Plyler and then a little bit further. So that's kind of what I'm going on. I definitely want to go back.
Plyler is also a good burden. The burden on the marginalized group is,
Right, and
that's
it's
good.
an excessive, once again, excessive burden that prevents them from ever.
Good.
So
good.
It's kind of what I've got. I definitely want to go back and do the comparative case chart and see what else I can.
It really helps. I mean, I still, do it today myself, and it really helps with clarity. So.
Yeah. Cool.
Okay. So Alexis, any?
You're probably not as detailed as that quite yet.
Just take a stab at it. That's the point. Is not to have it finished, but to be, working through it.
Yeah. So I guess my issue would be whether it survives rational basis review. But thinking about that, just a question: would I have to say that it doesn't deserve strict scrutiny, or
nope,
because
you don't have to. If you're concluding it fails rational basis, you don't have to address
it.
Doesn't matter.
Okay.
And you can literally use the language from Romer. We're not going to think about heightened scrutiny because we conclude that it fails the most deferential.
And then rational basis review. I don't know my rule yet because, there's
the sketch of your rule is, there are two. So it's a similar kind of question to what Will's asking, but you're taking it in a little different direction. Okay. It can, there can be an absence of a legitimate state interest, there can be an absence of a rational relationship, or there can be the presence of an impermissible function, which is creating a permanent underclass. And then that's the one you need to say, okay, what does that mean? Does this law create a permanent underclass? Well, what's my rule? Let me look at the cases that have talked about that idea. And then Cass Sunstein has an article, there's ideas around a lot, but the idea of the anti-caste constitution. So you could find just one piece of scholarship
Who is that?
Cass Sunstein?
Cass, C-A-S-S.
CASS, yeah. I think Bill Askeridge talks about that a little bit too, that idea. But again, just limit yourself because you guys will go crazy otherwise. But
Yeah, how much should we be looking at, like secondary sources?
not a lot. Yeah, I mean, I'll give you one or two,
Okay.
you know, but that's just, you know, that'll
To help
be
structure
distracting.
the
Yeah.
discussion.
Yeah, you kind of just want to look at the best one. I mean, for yours, the question, what is rational basis review, is pretty unexplored, honestly.
Okay.
But I'll think about it.
Okay.
Okay, there's something. I mean, you don't have, you know, I personally prefer not to use scholarship in writing opinions, but you know, sometimes it's makes
Yeah.
sense, but you don't have to do it for sure. So you're going to use one or more cases.
Plyler, definitely, and then I'm not sure about
Well, so the marital status cases too,
which are.
which really go to, that's interesting. Yeah, you probably want to stay away from more cases about kids. I mean, so the amicus brief that we wrote is really about this idea, but they're all kind of cases about kids. So marital status is, you know, if you're born outside of wedlock, you know, you can't be permanently, you know, you can't be denied all these sort of survivor benefits and sort of placed in this underclass by virtue of that.
But I don't think that's really the issue, because this isn't about whether the children are born out of wedlock.
No.
And the children aren't deprived rights, are they?
Well, yeah, I mean, children aren't deprived. It's not about children, it's about the idea of it being impermissible for a law to create a permanent underclass,
Yeah.
which the court has expressed most sort of poignantly in the cases dealing with children. But you could pair Romer and Plyler to develop this political underclass theory.
Okay.
And then I would bring in maybe, you know, one piece of scholarship.
Okay.
Maybe Brown versus Board of Education also kind of goes to that. But yeah, take a look at, I mean, Plyler would be a great case to work with. Okay, you know what else? Zablocki. Zablocki versus Redhill. Z-A-B-L-O-C-K-I. Because that's what, you know, one of the marriages of fundamental right cases. But that would support the idea that excluding people from the institution of marriage interferes, you know, it is having this function of creating them as a permanent underclass. And so that's a good example of how in equal protection arguments, an idea could be relevant under like the fundamental rights discussion, and here it's relevant under the rational basis review discussion. So there's a lot of echoing oftentimes, but you can use that case, I think, to make that argument. You know, if marriage matters, then depriving a group of marriage is subjecting them to, you know, sort of second-class citizen status. Okay.
So should I be focusing on particular cases? I mean, I know that I'm like kind of using the Eskridge article. I feel like mine's a little bit different because I'm maybe looking more at law review articles than other.
Well, because you're sort of saying you're not really accepting the law as is. You're trying to change, you know,
Right.
kind of change it. But so the gender cases are the ones that kind of talk most about the idea of relationship between ability. You know, does this trait somehow inherently limit your ability to contribute to society?
So U.S. and Virginia.
Yeah. So I don't want to read too many of them because those cases are really incoherent. But Virginia, JEB is a preemptive strike and jury selection case. Craig versus Boren, Reed versus Reed, sort of the earliest one, and then Mississippi University for Women versus Hogan. So you want to focus on ability to contribute to society. Well, Claiborne, I think is the best case on that. You know, I don't know that I agree with that premise that because your ability to contribute to society is kind of limited, that it's kind of open season.
Right, I know. I was kind of afraid of going there. I was like, do I want to go there? I mean, because it works for this group, but not for, could like set some bad precedent.
Yeah, no, I think that's a good thing to be cognizant of. But you can also kind of carve it out as, just being, well, this is an easy case. It's an easy case where it's clear that the legislative classification is drawing on a trait that we all agree has no relationship to ability to contribute to society. So if you state it as the affirmative rule and rely on the gender cases versus the negative side of the rule, and rely on Claiborne, it'll have a little different effect. Well, and for history of discrimination, what the courts do is compare it to, they compare gender to race, right?
So kind of loving a little bit.
Well, so this is what I'm realizing writing my paper is the court never explains why race is a suspect classification.
Right,
It just
I know,
says it is. Yeah.
it just is.
So that's a lot of times why the most guidance we get on suspect classification analysis is from cases saying this is not a suspect classification. But the gender cases, again, I think actually would be a great source for that, right? So, it kind of relates to political powerlessness. It kind of starts to overlap a little bit, but, well, look at Lawrence v. Texas.
Okay.
And, yeah, you could go back to Bill Eskridge, and some of his work there too. But yeah, I think the gender cases are probably the ones that speak in the most depth about what the history of discrimination looks like. And put both what it looks like and why it's important. They put a lot of emphasis on it. Okay. The issue with sexual orientation is that it sort of has this different history of not being a coherent social group, and so not being sort of, oppressed across the board, and then as it emerges, laws coming down, harder and harder on sexual minorities. But, things like just the existence of anti-sodomy laws, things like Amendment 2, the anti-marriage amendments themselves could be, from one perspective, could be argued as evidence of a history of discrimination. Okay? Cool. Very exciting, you guys. Very, very exciting. I think it's going to be I cannot wait until tomorrow.
Can you listen to it, or?
I think that I don't know if it's simultaneous audio, but I think they do make it available. Yeah, okay. Yeah. So.
That could be fun to listen.
Well, it's like the conversation we had. What's the difference between the transcript versus the audio versus the video?
Like what their tone is.
Yeah. Who's interrupting whom?
Right. Although I wonder if you're listening to it, do you know who's speaking?
Well, they wouldn't announce it every time. Yeah, so you'd have to recognize their voice, which I wouldn't be able to do. But yeah, I like the cold transcript for whatever reason. So
there's like more data if you go by video, because you get oral and visual, but at the same time it allows you to kind of read into stuff that's not concrete, or like a transcript like that's.
It is what it is. Yeah. A transcript is an artificial distillation in its own way, but I just kind of prefer it because you exclude some of those, some of the soft factors. It's going to be fascinating.
So for next week when we have individual conferences.
Yeah. Well, so we can go ahead and schedule some stuff now. So I'm here Thursday and Friday of this week if anyone wants to meet this week. And you can tell me now or you can email me later.
What are you hoping? Do you have, because today was our topic sentence.
Yeah, and I don't know, can I have your copy? And you wrote a lot of notes on yours. Or do you have an extra copy? Okay. Do you have something you want to give me? Okay.
Not yet.
So let's start with you.
Okay.
And let's meet. Whatever form your expanded outline is in. But do you understand the concept of the topic sentence outline now? Okay. So I'd love to meet this week. Okay.
I can meet either Thursday or Friday.
Okay. What time on Thursday?
Between 10:30 and I have class again at 2:45.
So, I'll meet at 1.
Okay.
try your hand at this topic sentence outline, and then just bring that with you, and then, you know. And it's just, it's like, at some point, you have to kind of banish uncertainty and just plunge in and start, like I said, start making assertions, and then when you try to support it, you say, oh, this works or it doesn't work.
Yeah, it did help kind of go, like, even though you've thought, like, kind of mentally outlined, it's like nice to have it on paper so you can be like, okay, that, like you said, that's like not logical there, you can strike it and then kind of reorganize.
Yeah.
Or you can say, okay, that's actually where I'm gonna go.
Do you want to meet this week?
This week, I prefer not to.
Okay,
I
we'll wait till next week.
have a brief due Thursday, so that's gonna be taking up most of my time.
Okay, then we'll schedule something for next week, but you'll be in
Okay.
class on Wednesday, so we'll schedule at that point.
Okay.
Okay. Do you want to meet this week? You good?
I think next week would probably be more
Okay.
beneficial.
Okay.
Because then I think, today's class was helpful to help me fill in my topic sections.
So what you should be thinking about, we'll look at the calendar here real quick. So we'll call this, week 1, 2, 3, 4, and 5. So you have, time. We just want to make sure to make progress because, there's a lot of ideas here, right? So,
And my goal is like to do this comparative case chart. And make sure that my synthesis of this rule is backed by precedent and supported.
Okay.
The other thing I was kind of leery on too is like, I don't really talk about classification, I just kind of go into like, sexual orientation is analyzed under rational basis review.
All you need to say is,
I think I need to find the specific support for that.
there is no support because the court's never said it as an affirmative proposition.
True.
It's just defaulted.
Yeah.
So I would suggest
That's
you
like
do the
almost by
same thing.
omission.
Yeah.
Okay.
I would do the same thing.
Do you know where I could find that anti-cast?
The anti-cast principle?
No, the cast unseen article you were talking about.
Yeah, well, send me an email and I'll email it to you.
Okay.
Yeah. Okay, so actually, that would be a great goal for our meeting next week. So what we're doing, we're going back and forth between large-scale organization and small-scale organization. Large-scale organization is like the topic sentence outline. It's like, okay, this is the idea I need to flesh out. Your comparative case chart, that's feeding into the small-scale organization, okay? Because you're going to figure out exactly what you need to say about each of those cases.
Yeah.
Okay, so you want to have, let's see. I mean, for you, Kira, I think you want to start developing your paragraphs in this most controversial section. So, I mean, again, for me, when I want to get started, like I would do a summary of the Eskridge article and then revise that into, more sort of an analytical presentation.
Okay.
And I think then, why don't you just, use the gender cases kind of as your roadmap, the ones that I think it was 5 ones that I gave you. And maybe do a comparative case chart.
Okay.
Okay. A comparative case chart can really, can be based on outcome, it can be based on doctrine, it can be based on themes that are presented, so kind of just decide what level you want to pitch it at.
Okay.
But that would be a good goal for next week.
Okay.
And then you're going to try to do a topic sentence outline for Thursday. And then we'll check in then and see what's the next step.
Okay.
Okay. But yeah, you guys have plenty of time, but we just want to, break it down into different missions so you can get each of those accomplished. And if you have any questions in the meantime, let me know. We're going to have a really interesting conversation on Wednesday. I'm looking forward to it.
Yeah.
Should be fun. Okay, I'll see you guys soon.
Bye.
Thank you.
Yeah, I think Bill's doing due process from Moray.
Due process.
And Alice was doing some kind of rational basis.
Yeah. I'm like struggling with mine.
She I don't know,
she like gave me my topic sometimes when we weren't talking in her
Oh, yeah.
office, and I was like, that's really helpful. But now I have to fill it in, and I don't know how. I think that because you were doing it too, she like really pushed me to do this one. So
Oh, really?
and I'm like, shit, like I have no clue.
Have you read her article? Like maybe that helps. Because aren't you talking about animals? Read her article and just use that.
Yeah.
You just cite to her article.
Yeah.
You probably just got unlucky because my conference was just before yours.
Yeah.
Like if you had your conference first, I probably,
Like, oh,
she probably would have pushed me. So sorry.
No, I'm sorry.
I almost feel like, because I almost didn't even explore too much, I was like, this is what makes sense to me, so this is where I'm gonna go with it. And
Yeah.
she's like, okay.
Yeah.
So I think,
Well, I wonder if they're gonna reschedule that. What is it, a style event? I was
Oh,
a little
yeah.
nervous. I was like, I hope I'm on Will's team because haven't you done like a lot of mock trial?
yeah.
I haven't done anything
Yeah.
since STLA, so I was like, I'm gonna embarrass myself in front of these high school kids.
Yeah, I get kind of involved too, like, have they rescheduled it all?
I don't think so. I haven't heard anything.
No, I
But
don't
it's
either.
disappointing because I know like that they're going to supposed to come and all these like people are supposed to come and stuff. but
Yeah,
I
it
don't
doesn't sound pretty good. And then, so like, I thought we were like gonna coach the students into like what, like and have them do mock trial?
Yeah.
And then not just watch us do one?
I was like, should we like be meeting beforehand?
Yeah,
Because I
it's
don't
like all of a
know
sudden
anything.
it was like, yeah, here's a lot, like a rather large caseload that
Yeah.
everyone's gonna do something completely different on, but.
I just emailed Leilani, I was like, I maybe could do a direct, but I'm not doing an opening or closing.
Yeah.
That will be
I mean-
horrible for everyone involved.
If we have a little bit more time to figure it out, it's like, I still think we should, I mean, they're the students and they want to be
Yeah,
like
they-
away for a day. so
Yeah,
it's
they
like-
want to do it. They don't want to
Yeah.
watch us.
Yeah, exactly.
Like if they wanted to watch, they might as well go watch a real trial.
Yeah, they should, you know, they gotta be up there and
Yeah.
get their movie lines. and
I know.
Can't handle it. Well, I guess that's not legal.
I know. But I don't know, it sucks for Leilani because I know she was like working really hard on it, but then
Yeah.
she's also the symposium editor for Law Review, so like she got elected in February and they were like pushing her to start immediately, so she was like, I just need to get the style event over with and then I can turn to Law Review. And then the style event got canceled, so I don't
Yeah.
know if she's gonna reschedule or what. So,
Yeah, I hope they do. I mean,
yeah.
but it would be nice to kind of shift the workload on the students a little bit. Like, give that, send that, if they have like a list of people, like send that out to them and see what they can figure out. But it seems like a lot of work that would come back and forth with the students went out. Maybe it's like, how do you come up with something that like is beneficial,
Right.
but not like a ton?
I
It all
know.
sounds like the morning was scheduled for them to like just hear, like be a lawyer in a day,
Uh-huh.
and then like, all right, then
Go.
either go watch law students do what we've told you about,
Yeah.
but it probably, if it's like a day event, it should almost just go like, here, you give it your shot, you know?
Did you even read the case?
Not really, but I was on STL, like.
Oh, is it the same case?
Yeah.
It's the car accident one? Or-
No, this one is like, it's kind of like a defamatory, there's like a threatening statement.
Oh, okay.
Like through like the cyber crime.
Oh, okay. I must have done SCLA the year before. So
Yeah,
it's
yeah,
like-
I did the car crash too. That one was like easy, even easier because it's like concrete.
I know. Right, yeah.
The cyber case one is like,
Yeah, that sounds hard.
yeah,
Yeah.
because you had to almost prove like it was like a threatening statement, and there's like the whole like reasonableness aspect of that too. No one really makes it reasonable.
I know. Were you a coach for that?
Yeah,
Okay.
yeah, like Texas and I have coached, we coached the
Oh,
last couple of
cool.
years.
That's awesome.
Yeah, yeah. It's almost nice because it's like you still kind of stay involved. It's like kind of get to hone your own skills and start watching, you know, trying to teach it to people.
Mhm.
But you know, I actually do all the work.
I know.
So,
I think it'd be hard to be a coach. So I feel like it varies. Like some coaches are really good. And
yeah,
All right, see you guys.
yeah.
my coach like
You're
taught me
gonna find
evidence,
cases.
like stuff. I just like memorized like the like objections, like
Yeah.
having no idea what they mean. Like
Oh yeah,
the probative value outweighs, and I was like, I have no idea what I'm saying, but
Yeah.
like my coach told me to say that.
Yeah.
Whereas like I feel like
Yeah.
other
They
coaches
just
were
teach
just
you like all the talking points.
right, and you're like, okay, I guess I'm supposed to stand up and say this stuff about probative value. I have no idea what that means.
Yeah,
And
and I
then
would do that for like the first round.
Uh-huh.
This is what you want to say. Like, your emotions.
I was like,